fund or the NGO can prove that no such locally produced goods exist or local production capacity exists. But right now, all of the 7 goods under the PPE, ventilators, etc., supply stream, all are being produced locally, and there is a capacity to ramp it up. Secondly, Chair, we think that government has moved with commendable speed in providing this tax relief, but it's quite concerning that they have not moved with similar speed on other tax interventions that have been called for many years. So, for example, Chair, for more than 5 years, industry, COSATU, and other players, including the ruling party, have been calling for an export tax on scrap metal, and that hasn't been done. This has been raised time and again, and government has not moved with speed. We think government should move with speed and implement one immediately, and they can do that through an export levy without even having to wait for a tax bill. Chair, equally critical, we think that government has moved far too slowly on tabling the public procurement bill. It is now under public consultations at Treasury, but we want to at least see a firm commitment by Treasury to tabling it at Parliament via the medium-term budget statement in October, and then for Parliament to prioritize it and see if it can be adopted by April next year. We understand that normally legislation takes about a year for Parliament to process, but this is not ordinary times, and this is a critical bill to grow in the economy. Next slide, Chair. So just next slide. So, Chair, the other concern we have is around the timeframe extensions. So the bills give the tax relief until September. It's understandable why they do that. But I think, Chair, that is going to create unintended consequences and problems for us when it's very possible that you might find the alcohol industry is still under lockdown post-September. You might find gyms, sports still under lockdown. You might also find that some sectors of the economy which can operate, like restaurants, but remain operational under restrictions. I mean, they would need support beyond September. So next slide. So proposals in that regard, Chair, is that the tax relief measures within the bill should be linked to the timeframes and restrictions set by the disaster management regulations for those affected industries. The September reference should be amended to provide for that specifically, because you won't be able to come back with another bill in September if you need to do so. And then also lastly on this part, Chair, is that you would need to look at additional relief to be given to those industries. So, for example, excise duties payments that are due by the alcohol industry should also equally be deferred in conjunction with their restrictions under the disaster management regulations. Next slide. Next slide. In Koleleko, next slide. Chair, when the VAT was increased by Treasury during the 5th Parliament, there was a resolution of the 5th Parliament that relief measures should be put in place for indigent households. That was part of the ANC's 2019 elections manifesto. There was a broad agreement around it, but government has not moved with speed around it. Chair, and we think that now is the time to start looking at it. So our proposals, Chair, on the next slide, is basically we need to do 2 things. One is to implement increasing free allocation of water and electricity to all registered indigent households in all municipalities. And the second one, Chair, is to make sure that all municipalities are indeed still providing for a minimum level of free electricity and water to those indigent households. Next slide. Chair, just coming towards the end, and this is slightly outside of the tax relief bills, but I thought I should still raise it with honourable members, given its critical status. Government has done well to provide surety to loans to businesses through the banks for 200 billion rand. But Chair, we think Treasury has to intervene. The fact that less than 5% of it has been dispersed to date, barely 10 billion rand, is a major crisis. This 200 billion rand loan surety is a huge stimulus for the economy potentially. It can save thousands of businesses and hundreds of thousands of jobs. We think government is being far too soft on it. The banks are being far too conservative, and really needs to be made a national crisis intervention point. Equally concerning, Chair, was that when the banks informed us that government so far has only actually stood surety for 100 billion rand and not the full 200 billion rand. But I think it needs to be prioritized, and Treasury should be reporting regularly to Parliament and the public about it. Next slide. Chair, we do appreciate that in an economic crisis, it is quite difficult to increase taxes generally, more so in a recession. But we felt, Chair, that, and the Minister of Finance had alluded to it before, there is a need for solidarity tax, especially from the wealthy. We think, Chair, government should have looked at increasing income tax for those earning above 1.5 million, looked at increasing inheritance and estate duties, and also the luxury import goods as well. Chair, government needs every single bit of money it can, and it's equally important for the rich to pay their fair due in rebuilding the economy and capacitating the state. Next slide. So, Chair, lastly, and again, it's slightly outside of the parameters of the bills, but it's related to taxation, so we had to raise it. Chair, we've been raising for quite a long time as COSATU, and we've been working with Treasury and SARS around it, is the need to capacitate SARS. Chair, it's still unexplainable how less than 5% of import containers coming through our ports of entry are inspected by SARS to make sure that they pay customs duties and that the customs duties they pay are correct. Chair, that means we are losing a huge amount of revenue to the state. It means local industries and local jobs are threatened by cheap imports from other countries. It is a matter of crisis, we think, Chair, that cannot be allowed to continue any longer. And SARS and Treasury should be required to report regularly to Parliament on what are they. A simple proposal there, Chair, is that to deploy some of the personnel at the Defence Force who are said to be surplus to further capacitate SARS. So let me stop there, Chair. Import containers I must raise the additional issues. Thank you, Chair. Are correct.
You've made it in time. You
local
took
industries and local jobs are
almost
threatened by cheap
13
imports from other countries.
of your 15 minutes.
We think, Chair, that cannot be allowed to continue any longer.
Request the South African Institute of Tax Professionals to make their submission. 15 minutes.
Some of the personnel at the
Thank you very much, Honourable Chair and Honourable Members. Thank you once again for allowing us to provide you with our input. I'm going to share my screen if that's possible. Can you all see my screen? Then I don't need to ask for the slide to be moved. It will take a while. I just want to know if it has come up.
Yeah, we can see the screen.
Okay, there we go. Okay, thank you very much. First of all, again, we also want to thank National Treasury and Parliament for these bills and the way in which it was done, but we do have some concerns, and I'll address 4 of them today. The first one is the separation of powers, which we will separate from retrospective legislation. The second one is the COVID-19 organisations and the solidarity funds, the actual donations and the deductibility of those donations to those organisations. The third one is the case-by-case waiver of penalties, and the last one is the relief that has not been provided in the bills that we would like to see them. If we start with the first one, which is the separation of powers, well, our concern here is that Parliament's constitutional powers might be at risk. And I do note that this was expressed by various MPs at a previous meeting of the committees, where it was stated that the COVID relief measures were bypassing parliamentary oversight. There we go. Now, we do acknowledge that there are certain provisions in the law. Peter and Mr. Thomas, and it is permissible in the law, and Advocate Jenkins also reiterated that should these amendments not be acceptable or deemed proper by Parliament, that they could then be reversed. Now, there are various provisions in the law. There's about 17 to 19 of these in the Income Tax Act and the VAT Act, respectively, that allow this 12 months for Parliament to actually peruse the legislative changes to give finality to them. And this brings us to the concern that we have is, first of all, it's the constitutional mandate of Parliament to provide legislative approval. Currently, as we see it, not allowing Parliament to have oversight of the legislation before its implementation effectively reduces Parliament, and this is, as Mr. Travango, I think, said in the meeting, to rubber stamping the decisions of the executive, because the legislation would have been implemented based on the legislation before it was actually finally approved by Parliament, and this defeats the constitutional official mandate of Parliament. Now, that leads me to my second point, and that is the practical implementation of the legislation. So let's take, for instance, you have an egg, you crack it open and you make scrambled eggs. It's very difficult to make that scrambled egg to turn it back into an egg. Similar to this relief provided, it's very difficult to take the relief back once it has been divided. And this was raised as well, I think, in Parliament previously with the VAT rate change from 15%, although Parliament did not necessarily agree with it, they were left powerless to actually change it back to 14%. The practical side of this is where there was querying why relief was not available to him, because according to him and according to SARS, he did qualify, and we understood that the SARS system had been changed to actually automatically provide you with this relief. There were some hiccups in the beginning, but I think that was resolved. But he got the response from the SARS legal department saying that because the legislation hasn't actually been promulgated, that SARS can't change its system to make changes, and he'd have to actually apply for this relief specifically. Now, that goes contrary to that advice, goes contrary to what SARS actually did and was doing for many other taxpayers. But this version or this sentence is actually correct. SARS should not have implemented the changes on their systems until it was law, and it applies equally to businesses as well, having to implement systems before the law is actually finally been approved. So the problem here that we have once again is that we urge Parliament to look and reconsider the process being followed, because there is a concern regarding the separation of powers. We've seen that emergency bills, and bear in mind, this is an emergency. This was a crisis, it's a pandemic, things had to happen quickly, and we do acknowledge that the Treasury did do its job there, and we thank them for that. But emergency bills have been passed before in 3 days, and there were no mechanisms to actually put this in place. Or there are mechanisms to put this in place, so it is doable, and we wonder why it wasn't done here. So we want Parliament to ensure it has got its oversight rolled back, and saying that you've got the right to do it, but it's impossible to practically change that is not good enough, and it's basically superfluous. So they can have a look at that. We then move on to the next point, which is the disaster relief organisations, for which you'll see over here. They were non-profit organisations carrying on the COVID relief, and they were deemed to be public benefit organisations that were exempt from tax. Now, the law says they're deemed to be exempt, whereas the explanatory memorandum says they have to apply for approval to be exempt. On the donation side, so people making donations to these organisations, they were provided with a deemed deduction for these donations, and that is where our concern comes in, is how do you actually ensure that those deductions are correct? Is there an approval process that's just deemed to be deductible, but there's nothing in law saying how it should work, and we did confirm and engage with SARS on this, and they do agree that there is no process currently. We move on to the Section 18A approval, and that needs to be implemented. How is it implemented? So people need to be aware that when they do apply for the Section 18A on their EI1 form, they have to indicate Section 18A specifically. Otherwise, the people making donations to these particular organisations will not be allowed the deduction to be exempt. So we do request that the legislation be amended, and that the explanatory memorandum specifically mentions that in order to get a deduction for these donations, that Section 18A certificates are provided by the COVID-19 organisations as well as the Solidarity Fund, and this would apply, of course, to employers as well, where there is payroll deductible. But there's nothing in law saying. If we move on to the case-by-case, confirm and engage with SARS on this, and they do agree. Interesting one on the SARS website. I've taken it from the website. It refers to waiving of penalties, but actually it deals more with deferral of tax payments. So previously the relief was only provided for qualifying taxpayers that tax the income of or gross income of less than 100 million rand, and we do welcome the broadening of that to allow other taxpayers, larger taxpayers and smaller taxpayers that weren't compliant to actually try and get that relief as well. So we do welcome that. However, we do have concerns with this, is that, and we did note this in the beginning, that the case-by-case application is very administrative, not only from SARS' side or the taxpayer side, but specifically from SARS' side, and will create backlogs. And we'll see there are certain backlogs that have been created by the case-by-case waiver of penalties. If we look at what has been done internationally, very many countries have implemented relief, and we do acknowledge the hard work that Treasury and SARS have put into this, and we have generally provided all of these different types of relief mechanisms. But what we've seen they've done with the penalty waivers and deferral of payments and submission of returns is that they've given blanket postponement and deferrals, which will reduce the administrative burden for all concerned, both taxpayers and SARS, to help them focus on what's really important, that's saving jobs and continuing their businesses. The other concern is if you do not meet these requirements and you do get lumped with penalties and interest, you can apply for this deferment of payment. However, one of the requirements to get this deferment is you've got to provide security. Now, a lot of these small businesses, as we've previously seen, have applied for loans in which they have to also provide security, so they do not have many assets left for them to actually provide security to SARS. So we ask for a relaxing of this requirement, taking into account that this is really important, not only for the business to survive, but should they not turn able to make payment, they would then be regarded as non-compliant, and any future ability to get the relief mechanisms would not be available to them. And on this point, I'd like to highlight that I know Treasury did mention that there are about 9,000 companies that have applied for pay-as-you-earn relief. That was in April and 7,000 in May. To be honest, that seems a little bit low, and it is concerning why so many companies, small businesses, have not taken a lot of these relief measures up, and this would be one of the reasons why it is so low. If we move on to the relief that has not been included in the bills that we really would like to see there, and the first one is the essential service relief. A lot of individuals are putting their health and the health of their families at risk for no additional compensation, and we really feel that this needs to be acknowledged and they need to be compensated for this. We've given various different ways in which this can be done, but one of the easiest ways is to deem their remuneration to be a donation, for which they will get a 10% deduction when they actually submit the return. They could even do it via payroll giving, which would also assist them on a monthly basis with their cash flow. To be honest, similar provisions apply to the fringe benefit on care packages. A lot of employers are providing their employees with care packages when they are traveling, which includes hand sanitizers, water, tissues, a whole lot of additional things, food, while they are traveling back and forth to do the essential services. At the moment, as the law stands, they're being taxed on these fringe benefits, and we do feel that there should be relief in this regard. Another issue that hasn't been mentioned in the bills is the Section 1010 exemption, where a lot of individuals are stuck here and physically cannot leave the country, which causes a whole lot of taxation problems for them. And it also applies for companies as well, with directors sitting in certain countries now creating a permanent establishment for those corporates, which will add additional costs to the employers in potentially additional taxes being paid. And the last one is the Home Office allowances, as been mentioned by various MPs in this committee before. We feel that lots of employees are stuck at home and they need to kit up their offices or workspaces to be able to work from home. Employers are trying to help them with this, but unfortunately at this stage it is a taxable fringe benefit. There's very strict requirements in which you can claim home office expenditure. So we either ask for those to be relaxed, but the easier way to resolve this is just to allow everybody that is required to now work from home because of COVID to give them a tax-free allowance to actually get themselves set up to work productively and continue earning taxable revenue for our country. We've mentioned a lot of other comments in our detailed submissions to National Treasury, and we please urge you to have a look at those. It includes support for PBOs that are really struggling and generally cannot access this relief, and also the VAT relief, which is a cash flow problem for a lot of these small businesses, which puts them in default and then again denies them access to any relief that the government is giving to them. And that's it from my side. Thank you.
Thanks very much, Saika. You made it in time. You spent very few minutes.
First time ever.
No. We have to comment you. You have done very well. Your point very clear in a very limited time.
Thank you.
The next are your colleagues, the South African Institute of Tax Professionals. 15 minutes. If possible, those who are presenting can also put their faces for the sake of media and running, what do you call it? Is it YouTube?
Yes, Chair.
Yeah, we've got an audio streaming that we are doing, live streaming of YouTube and media. So from time to time, they request that we should also have our faces visible. Thanks. South African Institute of Tax Professionals, over to you. 15 minutes.
Thank you, Chair. I'm just making sure, can you see my slides?
Yes, I can see the slides and we can see your face.
Oh, happy days. I'm not sure about the latter, but the former is I'm very happy about. Thank you, sir. So when we look at where we are currently, there's, I think, 3 items that we would like to discuss from our side. The comments on the tax relief bills we will firstly address, and then secondly, the comments on additional measures. Like our colleagues from SAICA mentioned, there are certain measures that, due to time constraints, I think could not have been addressed in time. And then lastly, also in conclusion, there are other items that specifically from a cash flow point of view, we are very cognizant of the fiscal framework within which we have to work and the current economic climate. And there are instances where in a partnership between the private sector and government, we can find cashless ways in which we can alleviate some of the distress in the economy. And we would also like to then focus on that before we end the presentation. So first off, when we look at the employment tax incentive, the employment tax incentive proposal changed around about 4 times between when it was first introduced and when it eventually came in bill form. If you applied the first version, you had calculation that gave you, for example, X amount, and if you applied the last version, it gave you Y amount. The result is that for those that applied it in April immediately, they now have overclaimed from SARS in most instances in April and May, because they applied the legislation that was not yet promulgated. However, because it was incumbent upon them and SARS and government to implement immediately because of the COVID crisis, we're sitting with a situation that they now owe penalties and interest to SARS. We've approached SARS, and SARS has said from their side they will investigate how they can assist these employers, these affected employers, so that even though they applied the legislation as it stood at the time, well, the draft legislation, let me rather rephrase, they would then not pay interest and penalties to SARS. I think from an administrator's perspective, considering the fact that SARS and everybody had to apply the draft legislation at that point, that would be the correct relief to provide, and we would like to request that SARS be supported to provide relief in that regard, because currently the legislation does not allow them to just remit the penalties and interest in those cases. And at this point, to also then expect the employers to carry the penalties and interest would be just providing additional distress to them. The second item is the possible extension of the 4 months of the relief. Now, in this case, we are fully aware of the fiscal ramifications of this, so this is not something that we suggest lightly. We know that in most cases this will not be, fiscus will not be able to carry this. What we, however, do suggest is that since our tax system in most cases is based on the accrual system, so even if I haven't received cash, I am deemed to accrue it. Under the current circumstances, if I tax people on the accrual basis where they haven't received income, or in certain VAT cases, for example, if I look at rental income, you have to pay the VAT over it if it is due to you in terms of your VAT rental. The problem becomes that you must pay tax over on income or on rental income that you have not received, whether it be VAT or income tax. In both of those instances, the fact that you haven't received the cash makes it almost impossible for businesses, specifically those in distress, to fund that amount to pay over to the fiscus. And we realize that in most cases, the accrual system and everything works fine, but where we are currently, the lag between putting something into a bad debt and being able to, at that point, not pay the taxes over to SARS, or at least get a refund in those instances, the time lag is too long. So we would request that SARS has a look at that, and to see, in the case of, for example, excise taxes and so forth, where alcohol manufacturers cannot sell their wares, that at least in those instances relief is provided. On the second slide, when we look at the DA's non for tax administration purposes, we request that in instances where there are currently uncertainty between when lockdown applies and when lockdown does not apply. I know we're now in a phased alert level situation. However, it is not business as usual. And there are a lot of administrative functions that, even though SARS has gone extremely far in trying to make everything electronically accessible, I think between both SARS as well as the private sector, there are instances where, just in order to be able to meet the period demands of certain of the administration required in terms of the tax system, it's almost impossible. So if that could be re-looked, at least from a SARS and Treasury point of view, to see if there's not a possibility to at least give a bit more clarity as to when DA's non applies, and then to the extent that one would have to return to Parliament to amend the legislation to provide for another period of DA's non, to the extent that we have to go to alert level 5 again, if there would not be an easier way in order to do that. Because at this point, what we've seen is that any lack in clear communication means that people either A, don't take up relief, or if they take up relief, it results in problems with regards to interest and penalties, and a mismatch between SARS and the taxpayers. We now come to the additional measures. We would really like, in this particular instance, for both SARS and National Treasury, because some of these are administrative in nature, some of them are policy matters, and then specifically, Chair, to you and your colleagues, the mandate, in certain instances, we know the fact that we don't have cash flow, and the fact that the fiscus is where it is at this point, means that some of these incentives or this relief that we're asking for are by its very nature cashless. So if we look at the Section 12I tax incentive specifically, as part of the industrial policy projects that we have to meet a certain extensive set of requirements that are normally time-based, which means that in order for these industrial policy projects that got the Section 12I tax incentive to meet their requirements, they would need a thriving economy. That is what all their requirements are based on. However, in the current economic climate, they cannot meet this. There is no way. So as a result, we are requesting that there be a combined task team between Treasury and the DTIC to investigate ways in which government can give adjusted requirements, just so that we can keep these industrial policy projects going and keep the jobs that are affected, at least that they can keep on employing people. I think, at least from a COSATU point of view, hopefully that is also then aligned with their stance. I'm briefly just going to touch on the place of effective management and permanent establishment. This is the same as SAICA stated. Just consideration of the fact that creating a tax residence status change or creating a permanent establishment at this point in time, if we look at what's happening from an international precedent and policies point of view, we request that SARS and National Treasury please look at this to try to at least give clarity to most of our constituents and business in general as to how they should apply this going forward, because from what we can see, COVID will be with us at least until the end of this year. One thing that has been continually bubbling up from a lot of people is this globally mobile employees. Now, what this means is, if you are stuck in a particular country due to lockdown, and that results in you having to work in that particular country, what has been happening from an international point of view is that most countries have been saying, we will not take this into account in determining your tax resident status. This has always also been echoed by the OECD. The OECD agrees that we should not tax people and look at their tax residence based on the fact that they've been stuck in a particular country during lockdown. We would like the same treatment in South Africa. At this point, nothing has been stated under this. We would request that in phase 2 of relief, that this particular measure be investigated and that their clarity could be given around this. We realize that when we look at the budget that was provided in February this year, the business and the life in South Africa and the world has changed significantly. So to the extent it is possible to include this in this current, the bills that should come through this particular year, that would be much appreciated, because to provide clarity later, for example, only next year during next year's budget, would then take away the entire certainty that is required during this particular tax year that we're living through. Then under part 7, I'm just going to skip part of these slides lest I run out of time. Contributions to communities by taxpayers. In a lot of instances, big organizations are providing contributions directly to communities. They're providing services, they're providing assets, tests, etc. So in those cases, it's not clear whether they will be able to get a tax deduction, whether they will be able to say that there is not a donation, etc. So from that perspective, we just require clarity also from both SARS and National Treasury to the extent that that's required. Under the joint liability for employees tax, we're concerned about the fact that in a lot of instances, employers do not, if they go under, they do not issue IRP5s to their individuals, to the employees. And in those circumstances, if that employer did not pay the monies over to SARS for employees tax, then that means that SARS can then go after the individual, even though the individual never received the money. That means that individuals the whole country over could be held responsible for the failure of their employer to pay over the tax to SARS, to pay over the employees tax. We request that in order for those individuals to be able to prove that SARS that they did not receive that money, that they provide that information to SARS through a payslip rather than through an IRP5, which, like I stated, it's highly unlikely that they would have received from the employer if that employer in fact stopped trading at all. Then special remuneration, this is aligned to a certain extent with SAICA, in the sense that where we look at specifically our health service providers, where they are providing a massive amount of overtime services, that income not be annualized, so that they have a massive bump up in income, tax rate income in a particular month, but rather that it be treated as special remuneration in the same way that mine workers get for performing hazardous tasks during any emergency, which I think in this case we can liken to what health workers are experiencing currently during COVID. And we request that for that specific purpose, that at least that type of alleviation is provided to them during this period, that we don't tax them extensively during a time where we need their services more than ever before. I'm going to skip over home deductions and reduction salaries and benefits, just so that I think maybe in the reduced salaries and benefits, this is where a lot of individuals have given up part of their salary over a long period of time in order to assist a business to stay afloat so that everybody can keep their jobs. And in this case, we're just requesting that they not be taxed on money that they have not in fact received, and that there be a legislative intervention for that.
Hello, tax professionals, you are left with 3 minutes.
Thank you, Chair. In conclusion, there remain instances where government and the private sector can come together, where we can find ways in which the fiscus need not finance the expense of relief entirely in the short term. This is specifically if we can look at an improved process to unlock diesel refunds that remain due. There are millions and millions of diesel refunds that have not been paid out. And it becomes exacerbated as a result of the inability of SARS currently to do physical audits. So it appears that there are a lot of these stuck in limbo. We request specifically focus on that procedure so that we can get at least the diesel refunds going through the system quicker. Secondly, in terms of the mining industry, to investigate the possibility of granting limited access to mines to borrow a portion of the cash balances from their own respective mining rehabilitation trust funds in the event that it is felt that it can't sustain current drawing of cash balances, at least to upfront the monies so that at least they can start providing mining rehabilitation that can be done as it today, so that they can start using their workforce that cannot currently be used in terms of mining production. Then COVID tax relief measures. We're requesting more broadly than only organizations covered under Section 31 of the Income Tax Act to also cover private relief schemes that provide general relief and support to communities. Fiscal parity specifically, where if I receive money from the UIF under TERS, which is exempt from tax, but the similar employee receives income through a COVID-19 disaster relief organization, they are taxed, but me receiving the monies under TERS, I'm exempt from tax. Just requesting fiscal parity in that regard. And then fast-tracking the process for taxpayers to apply for structured payment agreements. I think we're echoing SAICA in this regard. Also, the waiving of penalties for late payment in terms of distress caused by the pandemic. We are seeing a bottleneck starting to happen, and we're requesting that a fast-track process be implemented by SARS to both assist SARS and the community itself. Lastly, Chair, I know this is a very tense subject when we talk about retirement funds, because we want people to retire with enough funds to enjoy their old age. However, where a lot of people are currently, this is their only potential place that they can tap to survive the COVID crisis. We're asking for enhanced access to retirement funds, such as allowing individuals to access their preserved retirement interest without the punitive rate disincentivizing early withdrawal, allowing individuals to further access preserved funds in cases where they've already taken a lump sum. And then to the extent possible, if it's at all possible, that they can start accessing portions of their retirement funds where they're currently standing in pension and preservation funds and even retirement annuity funds. In all of those cases, the fiscus need not necessarily be out of pocket, but it does require a mandate from government to National Treasury and SARS to focus on these matters, that we can partner with Treasury and SARS to find ways in which we can take some of the distress out of the system. Because we are seeing a lot of businesses and families that are under severe distress, and by working together, we can at least find a way for them to come through this COVID crisis with all their faculties intact. Thank you, Chair. Thank you to the committee.
Thanks, Institute of Tax Professionals. There is an echo. Can you please switch off mic and mute? Okay. Thanks, Institute of Tax Professionals. Let's now move to PwC, PricewaterhouseCoopers. 15 minutes, over to you.
Good morning. Can everyone hear me?
We can hear you, but we can't see your face.
Okay, I'll turn my camera on now.
Yes, please.
Okay. Good morning, members of the committee and Chair. Yeah, I'm not going to spend a lot of time on presentation today. There's not a lot that we'd like to raise. We'd like to just raise a couple of points that we feel are pretty important. We just move on to the presentation, to the next slide. Okay, so what we're going to look at is basically the ETI and how it interacts with the UIF and TERS, and effectively retrospective changes to the employment tax incentive, and then just a comment on the process and consultation. Move on to the next slide. Okay, I don't know why. Yeah. Is that the right slide? Okay. Yes. Okay. Section 4 of the Employment Tax Incentive deals with wage regulating measures and the national minimum wage. So basically, what Section 4 says is that where you've got a wage regulating measure, or you are paying less than the national minimum wage, you're not entitled to ETI incentive. Now, the TERS provides for, or UIF provides for payment of benefits to employees for the period of closure of a minimum of 3,500 Rand per month. The employer, in certain circumstances, and this is happening quite a lot, just to assist employees, is often paying a little bit towards, well, not paying the full salary of the employee, but is making sort of a contribution towards the employee's costs, and just to try and keep things going. And often that is in isolation, it's less than the minimum wage. Now, the effect of the two working together is that Section 4(1)(a) renders the employer ineligible to receive the ETI. So what we basically suggest here is that you just, for the period of the relief, Section 4 is amended so that it takes into account benefits paid to employees in terms of the TERS, for purposes of determining whether the employee is paid the minimum wage. Alternatively, that Section 4 should just be deleted for the period of, the relief. We can move on to the next slide. Okay, so expansion of the ETI, retrospective changes. Now, there were a few changes. There were a few versions of the bill that came out. The first bill, there was a second version, and then there was a third version of the bills. And in each of the bills, it appears that there was an increase in the amount of the ETI that was provided for. It's not entirely correct that there was an increase across the board. There was a relief afforded by the version of the bill that was dated the 1st of May, was effectively reduced in the version published in the version on 19 May, and in the 19 May bill and the final bill are essentially the same. And the reduction came specifically with respect to employees earning less than 2,000 Rand a month. So, where you have, we're not saying that we're against the increases that were made. What we are unhappy with, and what effectively is a retrospective change, there was a effective reduction in the relief in respect of employees who were paid less than 2,000 Rand a month. Now, compounding the problem is that the change only became evident during late May when the 19 May version of the bill was published, and at that stage, many of the employers had already claimed the relief. And furthermore, the information provided on the SARS website also reflected the provisions of the first draft, i.e. the draft on the 1st of May, all the way until the end of June. So you had employers relying on that, relying on the information for at least April and May, and only really clarified at the end of June. There was no sort of response document or commentary along with the 19 May version to explain the change. So yeah, I mean, the effect is that portion of the relief announced by the government and on which taxpayers relied is now proposed to be withdrawn with retrospective effect. Another thing that sort of compounds the whole situation, the whole problem, is that many employers acting in good faith actually paid, didn't say, look, I'm not going to pay anything. I will make a contribution. I will pay you an amount just to sort of tide you over. And that's, often that's less than 2,000 Rand. But, that means that the relief was actually reduced. So, yeah, I mean, it's not exactly a desirable situation. What we're suggesting is just to reverse the change that was made in the 19 May version of the draft bill back to the relief that was afforded in the 1st May bill, insofar as employees earning less than 2,000 Rand are concerned. Okay, if we can move on to the next slide. Okay, the final thing, I think this is just a comment. I don't think, sort of the horse is already bolted and we can't really do anything about it at this stage. I'm just having difficulty with talking to my slide because it's blurred, but I'm going to move on to my own presentation here. Okay, so we acknowledge that the economic effects of the pandemic and that they present significant challenges, and there's a lot of uncertainty. And I think Treasury, to a large extent, Treasury and SARS did step up to the plate here, and there was a real effort to get something in place, to get emergency measures in place. And we acknowledge and appreciate, and I think many people acknowledge and appreciate that the disaster management tax relief bills needed to be introduced as quickly as possible to reduce the uncertainty. I think the SAICA raised it earlier and said we could have gone a little bit faster. We have a slightly different concern in that many stakeholders have raised this concern, is that we could have had a little bit more public consultation. We could have had a more robust public consultation process and could have been more thorough. Now there was a meeting on 23 April in which it was sort of mentioned in that meeting that there would be parliamentary meeting, that there would be, once public comments were submitted, that there would be engagement with stakeholders through virtual small workshops. Parliamentary committees would convene public hearings on the draft bills. These workshops, there would be a response document presented, and the standing committee would see the standing and select committee would see these response documents, and then the draft bills would be revised, taking into account public comments and discussions and input from the committees. And then after that, we would only have an introduction in Parliament. Now, what we've gone here, we've had comments, we've submitted comments, and we've gone the whole length of putting comments together, but there's been no engagement with the public and stakeholders on the bills. Sort of just gone straight into introduction. Now, we understand the urgency of the situation. We understand that things needed to be moved quite quickly. But that is we would have appreciated, and I think everybody would have appreciated, a little bit more consultation and a slightly more robust consultation period. We recognise the fact that that couldn't be what it is normally in relation to bills in the ordinary course, but it would have. I think it would have helped a lot if there had been just a little bit of consultation. That in itself would have reduced a lot of uncertainty, and it could have even addressed and assisted in removing anomalies like the I don't know whether the under 2,000 Rand issue for the ETI is an anomaly or whether it was intended. Certainly that could have been cleared up, or it could have been addressed, or everyone could have understood what was going on a little bit better. We haven't had any feedback. We look forward to the feedback today from National Treasury and SARS, but we would have liked to have had the process be a little bit more robust and a little bit more involved. Okay, so I'm not gonna go on about that. One more thing that I did want to raise, and it was in the written submissions that we made last week, but not in my presentation, was just around time limits. Just bear with me for 1 second. Now we've got certain provisions in the admin bill, in the administration bill, the disaster management tax relief administration bill, that deal with time periods and fast tracking of value-added tax refunds, time periods, deferrals for payments of taxes, etc. Now, there's no provision in the in the bills for possible extensions of those. Now, given that this pandemic and the lockdown and slowdown and everything is sort of rolled on quite a lot longer than everyone anticipated, we would suggest that there be some provision in the bills for extension of these deferrals and these time period related allowances. It's just given all the uncertainty, and we don't really know how long this is all going to go on. Given that given these are admin bills, they're not money bills. It's something that can be delegated to the Minister of Finance to do it by way of proclamation in the Gazette or by regulation. So yeah, I mean, just a suggestion. Okay, with that, unless my colleague Carl Mandy wants to add anything to what I've said, I'll wrap up my presentation.
Okay, thanks. You are left with 2 minutes. Does your colleague want to make any comment before 2 minutes expires?
Thanks, Chair. No further comments from our side.
Thanks, PwC, for your presentation. The next submission comes from Dr. Ramola Naidu. Dr. Naidu, over to you.
Chair, it's Alan. Dr. Naidu is struggling to connect. I've got the IT person from Parliament trying to assist him as we speak. So I'm not sure if we should move on to the next item in the meanwhile.
The next item is Treasury and SARS responding. It will be a bit of a challenge if Dr. Naidu comes after Treasury will have presented, but be that as it may, because we don't have much time today, the parliamentary schedule is very tight. I think any indication as to how long will it take for them to assist Dr. Naidu to connect?
Not sure, Chair. The IT person is currently assisting him, so I can't even get hold of both of them because they're interacting with each other.
Is Treasury ready with the responses so far? If Dr. Naidu comes later, we'll find a way of accommodating him.
Thank you, Chair. My name is Young Amputa from National Treasury. I've got difficulties with my laptop because I can't show my face. It's an old laptop. That said, we want to apologize for Mr. Ismail Momoniat, who is our DTG of Tax and Financial Sector Policy, who is responsible for these tax bills. He was supposed to be here, but he has got another meeting. So he has requested that we tender the apology and we speak on his behalf and on behalf of National Treasury. Thank you, Chair, for this, and thank you for the comments received. At this stage, we want to say that we will consider the comments received. And in terms of the normal processes, we will do a response document to Parliament by next week, responding to all the comments that are raised today in writing. And then that's what we are proposing to do, that we will do a response document to Parliament, responding to all the comments that are raised today in writing. And if there are any changes that are considered, because the bills have been tabled in Parliament, we have to request Parliament to make changes to the bills in terms of the money bills amendment procedure. So that is what we're gonna do. So by next week, we'll be able to respond line by line on each and every comment that has been raised. And if there are any changes that the minister is considering, the minister will have to request Parliament to make the changes to the bills because the bills belong to Parliament now. I don't know if other colleagues have got something to say. Franz and Chris?
Thanks, Yanga. No, I think we could, yeah, it depends whether we can do the line by line responses next week if that's the best way. Thanks.
Okay. Okay. Thanks, Madam Younger and Chris. Can the 60-year-old computer be updated to get young people to assist? You can't get hold of Ramona than I do. Let's have to move, because we said Treasury will respond in writing next week. I think we agree, members, to their proposal, because there isn't much that they can do now. All what stakeholders have presented need evidence-based kind of responses. If they do that here now, it will just be giving overview and personal views rather than the response of the department and SARS. So we'll await the written responses next week. Let's move to the next item, discussion by members. Nkululeko and Alan, you'll have to assist me with the identifying members who will want to ask questions or make comments. It's our management WhatsApp group. What do you call it? Is it group or WhatsApp group working?
Yes, it's working, Chair. For now, we've got Honorable Hill Lewis and Dr. George.
Okay. Honorable Lewis, over to you.
Thank you very much, Chairman, and to the presenters this morning for very helpful presentations. Particularly in dealing with the specifics of the bills, the presentations from SAICA, CITA, and PwC were very helpful. The problem with the presentation is that you only sent a PowerPoint presentation, and we are sitting here with the bills on our side trying to make notes of the things that you are recommending, but you haven't always given specific references. So I would be grateful if you could supplement your PowerPoint presentation with a written presentation, a written paper or a note, please, to send through to me or to the committee with specific references of the things that you propose. Because I fear that you know, rushing through your presentations, I will have missed a lot of very helpful suggestions. And if I may just say, for future, if you could make that a standard practice when referring to legislation, that you don't just make a point in your PowerPoint slide, but you also give a specific clause reference for your proposed amendment, that would be very helpful. Then I would just like to ask the team from SAICA and CITA, who made some proposals around pension access, their view on another proposal on taxpayers who earn pension income and who are provisional taxpayers, but their total pension income is below the tax threshold for their age. So what happens is, obviously, they have to pay tax upfront and then get that back at the end of the year from SARS because they're below the threshold. But in the meantime, they've got to stump up the cash. And a lot of them, I've had several queries from people in this position who particularly now face great hardship and can't come up with the money to pay SARS, knowing full well that they're going to get it back, but only after assessment. So I'd be grateful for your views on how we can alleviate the hardship of those people. Then, if I can go to COSATU, Mr. Parks, I really agree with the point that you made about the 200 billion rand loan guarantee scheme. And I would just point out, Chairman, that I have also written to you about this, asking that we have a meeting with Treasury to explain what progress they have made, because it is now more than a month since the Minister made his budget speech in which he committed to doing the things that COSATU have asked for and that I've asked for in my letter to you. but we've had no public announcement on progress there. So I still really think that that is an important thing, that we've got to get a briefing from Treasury on progress there. And I'd be grateful if we could schedule that as soon as possible. There's one thing that I really disagree with COSATU on, and this is my final point. I would just like to say to Matthew, you know, put yourself in the position of a small business owner in South Africa right now. You've just been through the worst 4 months probably of your life as an entrepreneur. You are every moment of every day worrying about how you are going to pay the bills, particularly people's salaries. And you probably have gone deep into personal debt to keep things afloat. You've maximized your TERS benefits. You've done everything. Take out loans from friends and family, whatever you need to do to keep alive. The government throughout this period has told you you cannot sell hot chicken because for some reason that has something to do with the virus. You can't sell pies. You can't sell this kind of shoe and that kind of shoe and this kind of T-shirt and that kind of long jacket, whatever the case is. All these completely bizarre, arbitrary and ridiculous rules which have further crushed the air out of your business. Now, Treasury has done the right thing to come to the party and say, here is a package of assistance to you as business people to just try and help you keep the doors of this business open, knowing full well that if we can keep the doors open, then there's a runway in the future where that business could grow and hopefully return to its former strength and size. So I really disagree with the idea that we should be adding more conditionalities on those businesses now at this time in order to receive those. I think it's something of a miracle, frankly, that they have got through these last 4 months of lockdown without shutting down entirely. And of course, thousands of them have. We know that thousands have closed their doors, but those that haven't have been by some miracle. And I just think that they need all the support and appreciation from us and from government that they can get, and should not be told, well, you can only get this lifeline, this little rescue lifeline, but only if you promise this and that and this and that to retain this number of staff. Well, the alternative is that the whole business closes down and everyone in that business loses their job. So I think that the fewer conditionalities we place on business at the moment, frankly, the better. Our outcome should only be, can we keep as many businesses alive as possible? And I would really ask you to put yourself in their shoes. Of an entrepreneur struggling to stay alive at this time. It's really not an easy thing. Thank you.
Thanks, Honorable Lewis. Dr. George.
Thank you very much, Chairperson, and good morning, colleagues. It is a pity that Mr. Mamoniat is not on today, because I think there are quite a number of issues that he does need to pay attention to. But in any event, on the presentations from SAICA and the Institute of Tax Professionals, my understanding is that SARS has made a statement regarding home offices, but it certainly doesn't seem as if they're doing much about it. So they're saying that people who have been locked down for a period, I think it was 6 months, they would be able to get some relief on their home offices, but they don't seem to have made any further accommodation, i.e. relaxing rules, etc. So I just want to know whether you've had a look at their statement and whether there's something I might be missing, because if that is so, then it is completely unacceptable, because SARS does need to bear in mind that this is a circumstance that people did not choose for themselves. They aren't locked up because they want to be, it's because they have to be, and therefore they should be getting some tax relief, certainly if they're working from home. And then also whether you've made any representation on vehicle allowances. I mean, we all know the problem with that. The people who get vehicle allowances can't use their vehicles, and that is going to cause a tax issue for them later on. So there's no reason why the formulae can't be amended in some way to make provision for this difficulty. And the reason why I say that is that SARS is spending a lot of money on advertising to people to be tax compliant, etc. And of course, we would want people to do that. But they certainly don't seem to be stretching themselves in terms of supporting, in terms of this real crisis that is upon us. I mean, the space is very tight, but there is an expectation because the social contract is a two-way street. Then on the pension funds, and specifically also the retirement annuities, we all know that on a pension fund, if somebody gets retrenched, they can access the pension, but obviously there's not always a punitive tax implication if they've been retrenched, but if they withdraw or leave the company and in order to take the money, there is punitive tax. And so we wouldn't encourage that. But on the issue of retirement annuities, for example, we know government's been encouraging people, especially business people, etc., to make provision for their retirement. But there's absolutely no way that they can access this at all until 55, even if they leave their employment, because that is a different kind of a vehicle. So everybody knows that, well, certainly I have been making proposals, and hopefully my bill will be processed quite soon, is that there is a way that we can, members can leverage their tax, their pension funds without incurring punitive tax, and also without withdrawing from the market at the bottom of the market. But there has to be will, and there doesn't seem to be any. So I would have wanted to know from Mr. Mamoniat is that clearly there must be conversations going on, but what are those conversations? Because we cannot wait forever, and it is a problem. So I do expect that we make some progress on that. Yeah, thank you, Chair.
Thanks, Dr. George. Are there hands, Alan and Kulek? Alan and Kulula, can you hear me?
Yes, Chair. We have Mr. Ryder.
Okay. Honorable Ryder.
Thank you very much, Chairperson. And yes, thank you to all of the people that took the time to put in submissions and make presentations this morning specifically. Comments I have, if I may. Notwithstanding Mr. Karim's comments in the beginning, I appreciate the opportunity to do that. Chair, I think that the absence of Mr. Mamoniat is, Dr. George did speak about it. I think it's disappointing, especially, I wonder what meetings could be more important than presenting his bills to Parliament. But fair enough, we note his absence. I think that certainly PwC wanted to engage with him a little bit more directly. I think we would have enjoyed that opportunity as well. A couple of points that I wanted to put out of the presentations, and the one specifically relates to the fact that there were retrospective reductions in some of the breaks that were given, and this was picked up by SAIT and PwC, and SAIT made the point that penalties are being levied as a result of liabilities incurred as a result of retrospective reductions. I think that's unconscionable, and I would really ask Treasury to strongly have a look at that. And if you are going to retrospectively reduce a benefit, to raise a penalty on that debt would really, it doesn't. I think that would cause people to become even more disillusioned with the taxation system and frustrated with it, certainly. I noted Syke's comments about the Home Office. I disagree that the easiest way should be followed. I think that there would need to be a hybrid system put in. People that have set up home offices at their own expense, etc. But I did take your point. I think that something needs to be done, and my own input is perhaps not to follow the line of least resistance. Again, the taxation of or the fringe benefit tax on care packages and allowances given to staff members for PPE, etc. I think that is something that really needs to be looked at. even if there's a limit, a monthly limit or a daily limit that gets placed on that. Obviously, we don't want people to get away with murder and put the monthly grocery bill in a care package form. But certainly, where there is a legitimate care package being given specifically for people that are having to work out in areas where they are exposed, I think that there should not be fringe benefit tax placed on that. And then this issue around the complexity of the tax regime. I really believe, we're talking about declaratory memoranda and things that small changes that are not announced, they're not coupled with a media declaration or something, but just a declaratory memo that's being issued. I think that we're making the system incredibly complex and difficult for people to remain compliant. The fact is that, look, I'm not an accountant. I've got a banking history, and taxation to me is an absolute question. I really struggle to follow it. I have massive sympathy for the entrepreneur in a small business who is trying to battle on, trying to keep his expenses down, but suddenly a large amount of his funds is having to go towards tax advisors and accountants just to remain compliant, just to do what is required of him. I really think we need to simplify the way we do some things and try and make it a lot easier for people to remain compliant. Having said all of that, Chair, I do think that Treasury's response has been swift. I like a lot of what they've done. I do think that some of what we're doing is rubber stamping. I have some regard for the fact that they operated swiftly. I do think that, as PwC said, they could have consulted a little bit more closely, because certainly that would have ironed out some of the issues that have been highlighted today. Chair, thanks again for the opportunity.
Thanks, Honorable Ryder. I'm told that Dr. Naidu has finally been connected. Dr. Naidu, are you there?
No, sorry, Chair, it's Alan here. Dr. Naidu has connectivity issues, so she can't connect, but she's more than happy to answer any questions if it's put in writing to her. But she's apologized that she won't be able to connect.
Okay. Before I call Honorable Karim, are there other members who would like to make comments or ask questions?
There's no one on our side, Chair.
Okay, thanks. Chairperson Karim, over to you.
Yeah, thanks, Comrade Chair. Well, firstly, I think we should thank everybody for their contributions. They've been quite useful. But I'd like to share, Comrade Chair, with yourself in particular, but all the new members, this issue which keeps coming up, it's a recurring matter. The role of Parliament in respect of tax bills, in particular, excise taxes and VAT increases in the one case, and Parliament in effect rubber stamping these tax bills. Now, we have discussed this before. SAICA has been present at many of those, and they're aware of the answers to that, not least the last meeting where this matter came up. So perhaps, I think, Chairperson, in this term, the COVID stresses will hopefully be, not hopefully, will in fact, I'm utterly confident, be over at some stage or the other. We should pay attention to this again and see. Just to remind you, Chairperson, I did raise this because, yes, we're not happy about the process. In 2014, 2015, we raised it with Treasury. We got the research unit to look at this matter. They came up with the very same issues that Treasury raised, including, I think, the court decision that came slightly later. We asked for parallels elsewhere in the world, Chairperson. We were surprised to see that even in the established democracies, many of these aspects of tax bills are dealt in a similar fashion, where there's a limited role and a retrospective role for parliaments, we gather. Secondly, Mr. Wright is right. We've never hidden it. When I was chairing the committee and the complexities of this issue, and how is it that, I've been chairing committees since 1998, sorry, and I've never experienced this, where sometimes you pass a clause in a bill that you don't fully understand. And it was explained to me that in the British Parliament, similar things were said by MPs who are far more formally educated in finance issues. I raise this because it keeps coming up, Chairperson, and I think we need to move on from here and do some work around it. And perhaps the people who critique us should themselves tell us where are their parallels for what they suggest we should do elsewhere in an established democracy. But we couldn't find it. In fact, if anything, it suggested what we are doing was not that dissimilar to what's happening in established democracies. I think also it's a very skewed thing from the SAICA. Really, it's the first time they're raising it so frankly. And obviously, as a politician, my hackles are raised. You know, to what extent are they raising these issues? Because they're committed to a people's organ, Parliament. And to what extent is it to rationalize some of their problems that they don't always get what they want? The fact, though, is that we do make changes to tax bills, as SAICA itself knows so well. We do. In fact, that's why we have an informal process first, and then the formal process, Comrade Chair. Because once the bill is formally introduced, then the complexities of going through the Money Bills Act process. In fact, constantly when the bill is introduced to Parliament, bills, we say to Treasury, now go to Tshwane or Joburg and meet with them. And I think you've done the same and will do in this term. You know, they must sort these issues out and come back. But Chairperson, on tax bills, you will never get consensus. Ultimately, people, upper class or lower class, don't want to pay taxes. Not here, not anywhere in the world. So you'll never get consensus. But we constantly argued that Treasury needs to consult more. And it's a point you've raised, Chairperson. I'm saying this because issues shouldn't keep coming up without us doing something about it. So on the VAT, SAICA is uninformed. That's not true. The committee, the majority in the committee, meaning the ANC, were unhappy with the VAT increase. However, finally, when we discussed it with everybody, including stakeholders offline, which the DA knew we were doing, COSATU and so on, we settled with a 3-year review. Little do we know we'll have COVID-19 hitting us this year, and that review doesn't take place. Now, many, many times, SAICA and PwC and others have come on the very day we're voting on a bill, Comrade Chair. And we've made amendments. Tandi, Tobias will remember, Dikile will remember one day on the other side in that M block, on the day we were voting on the bill, one of these organizations, SAICA or SAITA or somebody came there and said, look, there's a glitch in the bill and there's inconsistency and so on. And we made changes. Now look at the process we're currently undergoing, Chairperson. So they consult with Treasury and Treasury with them. In this particular circumstance with COVID-19, there's a much more sober reflection on this by PwC. They had to fast track things, right? Maybe there was more space to do more, but certainly it's not like a normal adjustments budget. So maybe Treasury should have done more, but let's ignore this for now because the processes SAICA is raising deal with processing adjustments budgets and budgets more generally, not a COVID special adjustments budget, right? Now, let's be clear. Treasury does consult with them. Each side will say, well, the one side will say we're over-consulted, the other side will say we're under-consulted. Then we send it back to Tshwane, even though the bill is in Parliament, sort these things out and come back to us. We also want to say that, you know, I don't know of any other committee here, maybe they want to refer us to a Parliament of a similar sort that does this. So they come to a public hearing. Then the researchers put together a report. National Treasury replies to them. Then they reply to National Treasury next week or whenever it is, Chairperson. Then Treasury replies to them, and then we open up clause by clause processing. So ask them to tell us which Parliament in the world does that, which committee in this Parliament does it. I don't know of any other committee, Chairperson. So they do get a lot of opportunity before the final bill is presented, usually with the MTBPS. So I want to say also, finally, that we should draw a distinction, please, between the exceptional COVID-19 circumstances that warranted this bill in the limited time span that all of us had, including Parliament now to process it, and normal tax bills. And I also want to say that, you know, Chairperson, with due respect to Yanga and Dion George and Dennis Ryder, Momo is a very accomplished, experienced, and, you know, as a former political activist of quite some repute. But he's not indispensable, Yanga, with due respect. You don't speak for him. As I understand it, you speak for Treasury and the Minister. If he's not here, it does not mean you cannot respond. You're a very accomplished representative of National Treasury on bills, on tax, and there's no reason why you cannot give answers. And your answer, with due respect to your younger and Treasury, that you will give a line by line next week is not at the expense of an initial cursory response, because the stakeholders are here. In these committees, we encourage an exchange between the stakeholders, Parliament, and National Treasury. So there was nothing stopping you, Younger. You're very accomplished in your team is to give initial responses and say, these are broad issues that we hear from you. We even saw your written representations to us. Many of these you've raised before in our consultations with you. Tentatively, these are our responses, Chairperson, but next week we'll give a fuller line by line one. So Younger, you knew you were on the agenda. You didn't negotiate with the Chairperson, Joe Maswangani, or Alan and them, that, you know what, you won't make a submission today. So I don't accept that, Comrade Chair, but fine, the committee accepted it, but as an individual, I don't accept it. Momo doesn't have to be here. He's great, but he's not indispensable, and you could have answered. So finally, Chairperson, where is this all going? Instead of having this debate every time somebody's unhappy with a clause in the tax bill that we are rubber stamping, which none of us wants to do, why don't we ask the research unit to do yet another study? The legal services unit helped us to look at what we can do. When it came to the VAT bill, Comrade Chair, several NGOs said they would go to court and challenge it. We were very unhappy. We said, okay, when you introduce a customs excise increase, right? When you say sin taxes are going up, you can't consult on that issue. Nowhere in the world, apparently, that's done. It'll be foolhardy. It'll affect the markets. People will go and stockpile cigarettes and booze and so on. Nowhere, Chairperson, does that happen, right? So that's a nonsensical suggestion. And the people who are implying that presumably know better than to say it, right? They are technical experts. We are not. So that's nonsensical. On the VAT thing, we weren't convinced that that qualified in that way, but we got nowhere. And the NGOs finally retreated. They never went to court, presumably because they checked. It's not easy. So what I'm saying, Chairperson, I would like to recommend, if I may, that the NA committee, because tax bills are mainly your baby, as it were, that you ask for another study to be done, get in Frank and a team, and see whether it's possible that we can isolate like excise and customs increases in the February budget, that we know it's fine for a minister to do it. But separate that from things like VAT increases and other aspects of the tax bills. And finally, I can assure you now, even if in Nicaragua just after their liberation, or this parliament shortly after 1994, people will still complain there was not adequate consultation. Sometimes it's true, most times it's a euphemism to say we didn't get our way. So that's my response. Chairperson, I'm pleading with you as the NA committee, do something and settle this matter. Otherwise, we'll keep hearing this thing. Thank you. I have no idea. Chairperson, can you rule my brother there out of order? He's laughing. He's staring at us and laughing there. I don't know why. That's COSATU.
Matthews, you are not supposed to share the screen with us. You have had your opportunity. It's our time now.
I've been tired of seeing you all the time.
Yeah, you will stand for elections in 2024. Now is our time. Okay. Thanks very much, Comrade Eunice, for your comments. And I hope Treasury will also take your comments very, very serious. That next time, if somebody is not there, they should come better prepared. He should not go away with the office. He should allow people to be equally capacitated and rise to the occasion, because it gives an impression that Treasury, anything to do with tax matters, it is only one person. And as we have said, Treasury is composed of many talented tax professionals. So I think let's correct that, young Chris and your team. It gives a wrong impression to the public here. And I think Momo also should be spoken to, that should not be that when it's not there, there should be no, less like there's a vacuum. No. It creates a very, very wrong impression. But I hope next time that will be corrected. But that as it may, we'll await your written response. And then, Comrade Chairperson Eunice, I will suggest that if possible, at some stage, we get the Solidarity Fund, whether it's the board or what they call themselves. I don't know what is the structure called, but I know it to be Solidarity Fund, to come and appear before the committee. Tell us who they are, give us the overview of their work, and explain to us their activities so far. The work of Solidarity Fund is of public interest. And platform, I mean, the parliament is where the public is represented. So I would suggest that Alan and Kuleg look for a space. I can see we've got a tight schedule, but from time to time, this issue of Solidarity Fund of that meeting. So if we can look at that and create space for them to come to Parliament, we'll appreciate.
Can I just come in there? I think it's a good idea. I think members might want to think about it too, but it would be useful to call Department of Trade and Industry and have it jointly if we can. I know it's difficult with the Trade and Industry Committee, because if I'm correct, I could be wrong. I think Solidarity Fund belongs to National, to DTI. Patel and them are managing it, Minister Patel, and therefore it would be useful to have them here too. Overdue. Please, if you can facilitate it, I'm sure the Select Committee will be keen to attend as well.
Okay. Thanks very much for that suggestion, Honorable Chairperson. Are there announcements, Kululek and Allen, before we close the meeting?
No, Chair, it's just that the stakeholders still to respond to questions raised.
Okay. Stakeholders, 2 minutes each. We'll start. Okay, let's go the way you appear on the list. COSATU, 2 minutes. Honorable Park.
Okay. No, thanks, Comrade Chair. Thanks to members. I think first to Honourable Hill Lewis. I think as COSATU we would support the proposals he made around giving some kind of tax relief, early rebate relief for pensioners. I think that'll be a useful lifeline to those pensioners. I think, Chair, we would also be quite keen for the Standing Committee on Finance and the Select Committee to have those engagements with National Treasury about what are they doing to unblock the 200 billion rand being released by the banks to the economy. There are very few lifelines being given into the economy. There's very little stimulus injections, and that really is a critical one. And it's quite worrying how slow the banks are in dispersing it. And really, we feel as COSATU Chair that the banks actually are stifling the economy when we can least afford it. I think the last thing for Honourable Hill Lewis, Chair, around the conditionalities. Look, we share the plight of employers, because you know when businesses go under, the first ones to suffer are workers in retrenchments and not being paid wages, etc. That's why as COSATU we put hectic pressure on government, on the UIF, to release to date more than 40 billion rand from the UIF into the economy. We're putting more pressure to expand that relief. But look, for us, Chair, there also are, not all employers are the same. There are some employers who took the gap immediately under the lockdown in the beginning of April to retrench workers en masse, not because of COVID-19, but because of their own mismanagement or corruption or callousness. There are other workers who simply had their wages being docked by these employers. So for us, it's a moral issue. Why should I bail out company X if they're just simply going to throw workers out the window? But we think, Chair, that yes, Hill Lewis is correct. We need to give every bit of support to employers, to businesses, to keep them afloat. And that's why really other departments besides the UF, like small business development, like tourism, really have to come to the party, because the UF can't carry the burden alone when in this crisis. To Honourable Dr. George, as COSATU, we've had quite a few discussions around his private member's bill, around our proposal about allowing workers to access part of their pensions during the pandemic. We're quite keen to see his bill come through Parliament. We are having engagement with the Treasury, but to be honest, Comrade Chair, we think Treasury is not moving with the speed with which the crisis facing workers necessitates. Thousands of workers are literally resigning every day simply to cash out the pensions, and that becomes the worst of two scenarios. Lastly, Comrade Chair, I'm very worried if I become an Mbongi for the ANC members and for Yunus Karim, but I think the Fifth Parliament and the Finance Committee's chair really did fantastic work. They really showed what it was to be an activist parliament. And I think they really did a lot of excellent work in terms of our own engagements on VAT, the carbon and sugar tax, the retirement annuitization, and the PIC bill. So I think us as COSATU, we really felt in that committee they took public participation quite seriously. That is why we got the PIC bill through. And I think for us as COSATU Chair, we really feel the only way to save South Africa is a social compact between government, parliament, business, trade unions, to grow this economy. And I think, Chair, it would be useful to have that VAT review, even though we are in the pandemic crisis. But the Minister of Finance, lastly, Chair, has been talking about a review of the taxation, which we think is critical, and there's no better time to do it than now. We need to get it done before February, because the taxes that have been increased in the past few years, Chair, we really feel have been increasingly upon the working class and the poor, and we're allowing the rich to get away with it because they've got fancy accountants. And right now, government needs every single cent it can get to stimulate the economy. But thanks, members. And thank you, Comrade Chair.
Thanks, Comrade Matthews. Saika.
Thank you very much, Chair. Thank you to all the members for the questions. I'll start off with Honourable Hill Lewis's questions about the specific sections in the presentations that we were talking about not being provided to you. We did send our full written submission, last week Friday, with all the details, which also contained our submissions to National Treasury. That goes point by point. It highlights the sections, etc., that need to be changed. So I do find it strange that you don't have it yet, but it is included in our written submission. So you should find all the necessary sections in that submission. With regard to the pensions, I'm going to defer that till later. I'll chat to you about that just now. Honourable George had a question, as did Honourable Ryder, about the home office allowances. Regarding SARS' statement, I think it is your question there is based on an article that was released, I think, yesterday in the press, where it says SARS stated the following, that you get 6 months free or something like that you can claim. If you're at home for 6 months, you're allowed to claim home office allowances. I don't know if SARS can correct me here, but I'm not aware of any statement of that in that nature about home office allowances, other than the interpretation note that has always been there and the way Section 23B reads with all its specific requirements. So unless there has been a statement released that I'm not aware of, it is the status quo as it was before. There's been no relief provided other than what is in the section and then what the interpretation note requires. In that respect, we don't agree with the articles that are out there in the media and in the press saying that if you're at home for 6 months, you should be able to claim it because it's mainly used for work purposes, etc. I think that those sections have been interpreted incorrectly, and I think a lot of people will be claiming stuff where they haven't actually looked at what that mainly using that office for work purpose requires, and it relates per expense, not necessarily to time periods. So I think that is something that urgently needs to be revisited if there is no relief being provided. And I do take your point, Honourable Ryder, about the various options. The path of least resistance is not always the best. So we do agree with that. If it is a way to make it easier for taxpayers to claim, if it has to be via legislation, we do agree with that. But in the interest of time, we did suggest there is an alternative should that not be possible. In respect of the care packages, etc., as we said, yes, we understand that there is no, and that has been provided in our submission. There is no relief, as we understand at this stage, on those. So we would welcome changes. And in fact, we did suggest a limit as well of 200 Rand per month for those care packages to prevent abuse. So all of those details are in our submission. Honourable Karim on the whole power struggle, etc. There, we take your points. I've been at SAICA for a month, so Peter, I will ask you to come in just now. But the point made here is that this is an emergency situation. This is not our normal supplementary budgets that you referred to, etc. So we understand all of that. This was an emergency and is an emergency situation. If we look at I think it was the Sexual Offences Act that was changed in 3 days when it was unconstitutional. We've made submissions, as we've mentioned, to National Treasury before, and as we have been brought out in the presentations on the consultation. All of these, it could have been included in these bills. We wouldn't be sitting here now if we had all worked together in haste to get this approved. To get the consultations happening when they should be. It was an emergency situation, and we just feel it wasn't treated that way according to the processes that were currently followed, although we do accept what Treasury did. Back to the Honourable Hill-Lewis, I'm not sure I understand this enough. This is her forte. And Peter, maybe you can jump in here before as well, because I know SAICA, I think, was involved in similar things as well. If the pensioners are below the tax threshold, as far as I understand, that they should not have to pay tax, etc., and shouldn't be due refunds at the end. So I'm not quite sure how that works, unless it is where they earn additional income, and then there is a potential that they should be registered as provisional taxpayers. So I'm not too sure where the problem is that what you're talking about. Otherwise, it's the 25% that the pension funds would have to withhold. And if there's a problem with that, they would have to ask for a directive or a declaration in that respect. But I think, Peter, I don't know if you've got anything to add on that, but I know Beatrice, I think, will also talk to that point, as well as to the punitive withdrawals, which is also of concern, and the access to that is problematic. And we would welcome any future bills on that to change. Peter, I don't know if you want to add anything on the matters.
Hi, Sharon. No, I think we're pretty much out of time. I don't want to put pressure on the chair. I think we would welcome any review, just as to the comments made by Honourable Karim. We would welcome to participate. I think we did make a submission on the consultation process, comparative internationally as well, previously to the committee. And I think, just as a closing statement on that, I think we're just raising the practical problem, namely, if something has been implemented, so it's not about retrospective and retroactive, when something's been implemented without legislation, can you undo it when Parliament disagrees? And I think what we're proposing is just to make sure that when we look at things that are implemented on this 12-month, call it approval rule, is it something that you can undo? For example, pay-as-you-earn has a 12-month, call it life cycle. You can still undo that. But if it's something transactional, you might not be able to undo. And that was the practical problem we are seeing now. And I think that's the concern we've raised. I think that in closing, that's all we have to add. Thank you very much, Chair.
Okay. Thanks very much, SAICA.
Chairman.
Louis.
Yeah, I just wanted to clarify. I am talking about pensioners who are registered as provisional taxpayers if they receive investment income, but the total of that income is still below the threshold, but they're registered as provisional payers and have to pay upfront, and that they don't have the cash to do so. That's exactly what I'm talking about.
Okay. But that to say they sent us the document. Have you received the document that SAICA sent to the Secretariat? Louis?
No, I've just got your PowerPoint presentation, but I'm going to chat to Alan, the committee secretary, afterwards, and I'll track it down, Sharon. Thank you.
Yeah, it is there, but that point that you raised is not there, and it is something that we'll look into.
Thank you very much.
Thanks, SAICA. Institute of Tax Professionals, can you respond to their questions and comments from members?
Thank you, Chair. To the Honourable Hill-Lewis, with regards to the pensioners, the provisional tax, Sharon, thanks also for that. I would very much like to look at some of these cases, because sometimes if it just is a matter of making sure that we give the right communication, or at least let people know step by step what they need to do so that they do not have this hardship, then we'd be glad to assist. So I'll get in contact with the Honourable Hill-Lewis just to get the information from him in that regard. When we get to the Honourable Dr. George. The bill on the drawing on pensioners, that's something I think that has been really on the front of mind for a lot of individuals. And the one item there that I think that is critical is to, in the same way that we recognize for businesses that we are living in an exceptional time and we need to support them. So we are doing things that otherwise we would not be doing, we would not consider even doing. In this particular case, for individuals, things like withdrawing a portion of their retirement savings at this point is something that we have to look at. It is a matter of survival. So in that respect, considering the demographic of our country, in some instances, this is literally the only savings that people have. And we do not want them to lose their job only in that instance to be able to access their life savings. So from that perspective, we would really support Dr. George in that, and I'll get into contact with Dr. George just to see in terms of what that bill proposes. From our side, we would definitely support any less punitive measures for people to access. Then in terms of the vehicles, I think that's also the company vehicles where a person is currently being taxed if your vehicle sits in the garage and you cannot travel to work and back because you are working from home, you still have a fringe benefit. And in that regard, you're being taxed on something that you have no private enjoyment of. So where there are such instances, I think it would be, from a fairness perspective, a good move to make sure that we do not have unintentional hardship there. Then on the home offices, I concur with Sharon. I think there are a lot of issues out there with regards to home offices and a massive amount of misunderstanding. So to the extent that SARS could perhaps look at just providing some clarification. And again, in this particular case, we're not talking about making predictions, etc., going forward, but this is dealing specifically with the COVID lockdown period. So if it's something that needs to be done from a legislative point of view, that for this period, then that could also be looked at, because I think also putting that entire obligation on SARS within the legislation that was built solely for normal economic circumstances is also not fair. So National Honourable Ryder, thank you for the ETI. Fully agree. I think we should try to assist employers that applied the legislation or the draft legislation as it stood. Then on the PPE and so forth, in terms of support of that, we agree from our side. We do think that if there are instances where employers are, for example, paying for people's COVID tests, where that type of expenses are occurring, that should not, by its very nature, being seen as taxable. In the same way, if you gave somebody a hat and something for the 2020, or I think it was 2010 World Cup, now I've forgotten what time it was, but in any case, there was a specific exemption for that at that stage. And I think we are at least a country brought together at this point as we were at that time, just for a different reason. So the similar type of exemption could also apply. If there's anything else that I've missed, I'm happy to answer via email. Thank you very much, Chair, and appreciate the opportunity. We also would like to thank SARS and National Treasury for allowing us to engage with them. We appreciate it, and thank you to the committee specifically for this opportunity. Thank you.
Thanks, Institute of Tax Professionals, PwC.
Yes, thank you, Chair. I don't think there's anything that we need to address. I think apart from Honourable Hill-Lewis's query around specific sections, we also just repeat the comment made previously around us having submitted a detailed submission that goes through and sets out all the relevant provisions and legislative stuff. So you should have that. If you haven't got it, obviously just drop us a mail. We can send it through again. If there isn't anything else, then if I don't know if my colleague Carl is still on the line, if he'd like to add anything, but I don't think there's anything that we need to address.
Yeah, maybe just one comment from our side, just to add to what Greg said, and just in relation to the consultation process. Just to be clear, that we would certainly have liked this bill to have been fast-tracked, if you like, faster than it has been, and appreciating that it is going through a process which is not the normal process. Ideally, we would have liked to have seen these bills tabled by the end of April, but that does not derogate from the point that we were making around the consultation process, that that consultation process could also have been fast-tracked and could have been more effective than it has been, and hopefully that would have then resulted in us not even having to raise the points that we have raised, which are, as you would appreciate, are largely technical in nature, as opposed to issues and concerns around the policies in question. Just on the consultation process itself, it's one thing requesting written submissions, which is obviously an important part of the process and needs to be done, but that in itself is not always effective, because there are limitations in terms of how effective purely written submissions can be on their own, and it needs to be backed up with engagement through discussion between those making the submissions and the likes of National Treasury and SARS, to, if for no other reason, to iron out misunderstandings or lack of understanding insofar as the legislation or the draft legislation itself, as well as the comments that are being made by commentators in that regard, and hopefully arrive at a position where there's a common understanding, if not agreement, in terms of what is trying to be achieved. So I think, as I say, that consultation process is important, and just to repeat it perhaps was not as effective as it could have been in the current circumstances. Thank you, Chair.
Thanks, PwC. Before we close, because members have to attend the mini plenaries, Honorable Karim, do you have any comment to make?
No, Chairperson, except to ask you to look into this matter, apart from the way we managed tax bills and how consistent it is with our parliamentary role. You asked to nardering between the DA and COSATU to actually check whether it's parliamentary for Mr. Jordan Hill-Lewis to agree with anything COSATU says, given that he's in the DA.
So it will be career limiting for Hill-Lewis.
He might, when he gets removed from the DA, we'll know why. Then he must go and join COSATU's Matthew Parks, and sit on the other side of us.
Okay, no, that was on the lighter note. Honorable members will have to adjourn so that you have to attend the mini plenaries now and in the afternoon. Thanks very much, honorable members, select committee, standing committee, stakeholders, also staff of Parliament. Thanks very much. The meeting is closed.
Thank you, Chair. Thank you so much.